join us first. Okay, so it's 1 p.m. now, and I think we'll start this webinar. So thank you everyone for joining us for this webinar on director and shareholder disputes. Today we have with us two lawyers from Silvester Legal LLC. I'll be introducing them along the way. So just a bit about this webinar. Today we'll be having, they'll be presenting on this topic, and afterwards there'll also be a Q&A session. If at any point you have any questions, so please feel free to put it in the chat, and at the end for Q&A, we'll just me as the host and the moderator, I'll be posing some of these questions to our lawyers to answer. Yes, and so for me personally, I'm also very interested in this topic to see what are the typical shareholder and director disputes that companies face, and how lawyers have practical solutions for the situation. Yes, so introduction about myself. I'm Yuk Lun. I'm the founder of SingaporeLegalAdvice.com. We are a platform for individuals and small businesses that need legal advice. We connect our users with lawyers, free contract templates, and their other legal needs. So with that out of the way, I'll be introducing the speakers for today. So first we have Mr. Walter Silvester, who is the Managing Director of Silvester Legal. He has a lot of experience with litigation matters, a lot of disputes that he has solved between shareholders and directors. And what is not listed here is also that Walter has experience in crafting a curriculum for London School of Business Law Diploma. And our other speaker for today is also named Walter. It's Mr. Walter Alexander, who is head of corporate at Silvester Legal. He has worked under the tutelage of the famous senior counsel, Mr. Devinder Singh, for many years, and has now joined Silvester Legal in a role of helping clients solve their problems using contracts. His litigation experience will be very relevant here in presenting corporate solutions for his clients' complicated arrangements. So without further ado, I'll hand over to them to tell you about more about how to resolve disputes between shareholders and directors. So disclaimer first, that this is not legal advice, and this can only give you a general overview of of this topic, and that you should still consult lawyers for any specific queries. Yeah, thank you.
All right. Hi, good afternoon, everyone. My name is Walter Alexander. Again, thank you, Yuk Lun, for your very gracious introduction. We are actually very grateful to you as well for the work that you're doing for Singapore Legal Advice. I personally think that you've done a lot to make legal advice accessible to people on the internet. And thanks for inviting us for this talk. Okay, so today we're going to be talking about shareholders and director disputes. And we're going to start with outlining what are different types of shareholders, what are the different types of directors, and what are their rights and obligations respectively. So why don't we, before we get into the disputes, of course, we have to have a good understanding of what shareholders and directors actually are and what their rights and their liabilities might be. So why don't we move on to the next slide? And the next one, actually, I think, as well. Okay, so now just another disclaimer. I haven't timed this, and I'm hoping that I will be able to do this quickly, but it's a lot of ground to cover. There's a lot of ground to cover, and we're just going to tackle the topic in a very general way. There's a lot deeper that we can get into, but we won't try not to get too deep and allow some time for you to ask questions later on. Okay, so in terms of shareholders, what are the types of shareholders out there? Okay, if you're a shareholder, you would already know this. But basically, there are ordinary shareholders and there are preference shareholders. Now, ordinary shareholders are basically, that's what it is. They're ordinary. And in terms of distribution of the profit and so on, you get a distribution of profit, but you do so only after the preference shareholders. And preference shareholders are usually those that actually get a higher priority in terms of the distribution of profits and profit distribution. Okay, usually preference shareholders have non-voting shares. They don't actually vote, except in certain situations. For example, when the company is going to liquidate, or if there's a referendum to change the terms of preference shares. Okay, now what are the rights and obligations of shareholders? Okay, the good news for you, as if you're a shareholder, is that you have a lot of rights and very few obligations. Okay, so that's the good news. So you have a lot of rights. You have the right to vote, right? Each of your shares comes with voting rights, generally speaking, and it entitles you to one vote on any resolution. And you are free to vote purely in your self-interest. You don't have to report to anybody about why you're voting in a particular way, generally speaking. You have a right to call and attend meetings like EGMs and AGMs, and you should actually attend an AGM at least once a year. Although you're not mandated to do so, you should be attending meetings and you have the right to do so. Also, you have the right to be treated fairly. Okay, and Section 216 of the Companies Act provides recourse to any minority shareholder who is being oppressed by the majority. And we're going to spend some time to talk about this, the claim in minority oppression later on. Okay, as a shareholder, you also have the right to peruse the company records and books. And by these, I mean the audited records. And you should be able to do that. Nobody should be stopping you from doing so. Dividends, you sort of have a right to dividends when they are declared. Okay, but it's not an automatic right to expect dividends every time. But you should be receiving dividends if you're a shareholder. The courts will generally not intervene to compel the declaration of dividends except in exceptional circumstances. Okay.
So it's 280 plus.
Sorry, that's not coming from me, but I'll continue. Then there's a right to assets of a shareholder has a right to assets when the company is being wound up. Okay, that's pretty self-explanatory, I think. Okay, now for a shareholder, yes, you have certain obligations, but compared to your rights, I mean, these are actually very minimal. For example, you have to pay for your shares. You're obligated to do so, right? You're actually buying partial ownership of the company, and you should be paying for your shares. If you don't pay, the company has recourse against you for that. You are obligated, generally speaking, to go for AGMs, right? You can actually nominate somebody else to go for you, but basically, if you're a shareholder, you should be going for general meetings and voting on resolutions. I think the other thing that we need to highlight is that you, as a shareholder, you might be a party to a shareholder agreement. And as a result, you better know the terms of your shareholder agreement well, because you are obligated to basically act according to what you've agreed to in your shareholder agreement. Okay, so these are some of the obligations that you have as a shareholder. And just to clarify, a shareholder agreement is slightly different from the constitution, right? They're actually two different documents. The constitution of the company is the internal regulations by which a company is governed. A shareholder agreement is a private agreement that's typically between two or more shareholders of the company, to which the company may or may not be a party. Okay, but there is a relationship between the two documents, even though they're separate. Your shareholder agreement should not contradict your constitution. It should be consistent, but it is a separate document governing the rights and liabilities between shareholders. Okay, now we're going to move along to directors. So what is a director? Okay, there are many different types of directors, and we're going to go through some examples here. Okay, so what is a managing director? Now, before we get into this, it's important for us to, I think, know that names in directors or titles may not necessarily, if you're a director in title, it may not necessarily mean that you are actually a director in law. Okay, a director in law is someone whose name is listed in your ACRA search for your companies. If you are in the ACRA search for your company, that means that you are definitely a director and you have duties and obligations to the company. But if you are just in name a director, that doesn't necessarily follow that you have those same duties. However, you do need to check and see, what are you actually doing? Even though you may have the title, what are you actually doing? The courts sometimes look at whether or not you're actually acting as a director versus whether you have the title of it. Okay, but let's start with managing director. Usually, as managing director is a director in law listed in ACRA, and in the constitution, a managing director may have actually an additional vote on the board of directors. So it's a very important director. Usually that is the case, but sometimes it may be different. Okay, what is an alternate director? An alternate director is generally another director or a person who is approved or appointed by a director to act in his place if he's absent from a meeting. Okay, that's an alternate director. Nominee directors are persons who are appointed to the board of directors of a company by an appointer. Okay, and this appointer is usually a person maybe with a large shareholding in the company, and he's appointing the nominee to represent his interests. Or it could be, in many cases in Singapore, sometimes a nominee director is the only local director of a company, and the rest of the directors are foreigners. So these foreign directors, they appoint somebody who's local, and this is a person referred to as a nominee director. Okay, an executive director are usually members of senior management and involved in the day-to-day running of the business, right? So executive directors are expected to provide insights to the company's day-to-day operations, provide management views, and collaborate closely with other directors for the long-term success of the company. Now, non-executive directors are not part of the management. They are not employees of the company, and oftentimes they do not participate in the company's day-to-day management. But they are still, in the eyes of the law, directors, and they need to be familiar with the business and stay informed of the activities of the company, and also at certain times challenge the management or help them to develop proposals on strategy. Okay, what is a de jure director versus a de facto director? A de jure director is a director who's formally appointed. So for example, somebody who is in Accra, right, who's listed as a director in Accra. What is a de facto director? A de facto director is different. They may not be validly appointed, but they are held out by the company as a director. Remember earlier I said that there may be some behaviors that people have, certain behaviors that they behave as certain directors, even though they may not be actually appointed as such. Well, if they exercise their powers as directors, the court can sometimes say these people are actually de facto directors, even though they're not listed, for example, in Accra or whatever it is. There's a case, an interesting case that talks about the distinction between the two, which is Cheng Tin Jin and Alvama Capital, where it was clear that the plaintiff exercised real influence in the company and participated in the management of the affairs of the company on an equal footing with a person named KP, who was the company's only formally appointed director. And so this person, even after his resignation as a de jure director, continued to participate as a director in almost all aspects of the company, including in finances, banking, HR, and even client-facing dealings. So this person was considered by the court as a de facto director. Even though he wasn't in name, he was in fact a director. Now, what is a shadow director? Shadow directors are slightly different from de facto because they exercise their powers indirectly by controlling those who are nominally in charge. So where a party is adjudged to be a shadow director, he may not be a director under the Constitution and so on, but he is actually exercising some form of control over someone else who may be a director. And the case of Sake Holdings and Griffin Real Estate is a good example of how that happened. There's a person who was named Andy Ong, who was acting unilaterally in key areas of corporate decision-making. And there was this other person, Ho, who relied on Andy Ong's instructions to the point of unquestioning deference. He deferred to Andy's wishes all the time. And in fact, he knew very little about what was going on in the company. So the court held that Andy Ong was actually a shadow director, right? Because he was actually the person behind Ho, was actually in control of what was going on in the company. Okay, what are some of the rights and duties of directors? Okay, so compared with shareholders, I got bad news for you if you're a director. You have a lot of duties and obligations and very few rights. But the good news is that when you're a director of a company, you have the power to act on behalf of and actually bind the company in any matter, right? As well as some of these other rights that you have. You're quite powerful in terms of the fact that you're actually moving the company forward based on your own decisions, right? But you have a lot of duties. And let's go on to the next slide or next few slides. And the main thing I think that we need to highlight here is that you have, as a director, you have common law duties and you have also statutory duties that you owe to the company. Okay, but just to give you an overview of these two types of duties are very close and interrelated. In fact, there's overlap. And so if you look at this slide that I've added here, it may help us to understand it. I know it's not very clear, but what it actually shows is that the two types of duties, statutory, that means coming from statute, the Companies Act, and also common law duties. Common law duties are duties that are not in the statute, but it's sort of like in general law, it is recognized that directors owe these types of duties. Can you see that there's an overlap? So in fact, if we talk about common law duties, we will also be dealing with, because there's so much overlap, with the statutory duties. And so that's how I want to deal with these types of duties today. We'll go through them in summary fashion. Okay, so let's talk about fiduciary duties. And this is found in section 157 of the Companies Act. What is a fiduciary duty? When we talk about directors having fiduciary duty, it means there's a relationship of trust and confidence at the crux of fiduciary duties, which means that you as a director need to have a single-minded loyalty to your company, right? So mere incompetence is not a lack of good faith. The core principle of fiduciary obligations is that a fiduciary cannot act against his principal's interests. And in fact, if you breach these fiduciary duties, there are severe consequences actually for you. There's criminal sanctions, disqualifications may also be imposed on a director who doesn't follow those duties. And in fact, a company can sue a director for breach of his fiduciary duties as well. Okay, so that's under section 157 of the Companies Act. But I'm going to talk now, also go back to, how they're both related, right? So the common law, under common law, there's a duty to act in good faith in the interest of the company, right? So what does that mean? Okay, so for example, what is within the company's interest? So for example, use of company funds. Okay, as a director, you're allowed to use the company funds, but in what way? It must be incidental to the business. It must be spent for the purposes of incidental to the carrying on of the company's business. And it doesn't matter if like if a lot of money is involved. It is more of like, what is the intention that you had in order to carry out certain acts. And in the case of Raffles Town Club, there was a case where RTC was to pay their directors fees and expenses and consultancy and incentives fees in the amount of 15 million. It was a lot of money, but the court held that that as long as the work was done to further the company's business and the company's interests, it was okay. And the word they use is gratuitous transactions, as long as it's incidental or within the scope of business, is permissible as long as they're reasonably incidental and within the reasonable scope of carrying on the business of the company. But this does not mean that dishonest or illegal conduct is approved. If you could have breached your fiduciary duties, if the aim was to maximize the profits through a dishonest or illegal transaction. So of course, this is not something that is allowed by the court. Okay. Okay, the next duty under common law is actually this duty of loyalty to the company, otherwise known as a no conflict or no profit rule. Okay, it doesn't depend on the director's state of mind. The test of a conflict of interest is whether a reasonable person would, in the circumstances, think that there's a real, sensible possibility of conflict. Okay, this is something that's very important, and sometimes it doesn't occur to directors when they're making business decisions. In fact, the Court of Appeal said that even a mere possibility of conflict is sufficient for you to actually breach this no conflict rule. So you have to be very careful when you're entering into business transactions where it might be perceived there's a reasonable perception of conflict of interest arising. So what happens if, like, can a director act for two different companies? Well, actually, maybe some of you already are. And there's really no breach of this duty when you do act for two different companies. But the mere fact that you do so is not inconsistent with it. But you do need to disclose your directorship in different companies at the appropriate time. And this is also talked about in Section 156 of the Companies Act. And you must remember that because you have a duty of loyalty, right, to your company as a director. What happens when you have these two companies? You actually owe that same duty to 2 or 3 companies that you are director of. And so you must not act with the intention to further the interests of one to the prejudice of those of the other. You must not allow the performance of your obligations of one to be influenced by the relationship to the other also. So sometimes it's better for you to remove yourself from a transaction if it gives rise to conflict of interest, no matter which course of action that you take. Okay, and I'm just going to move on here. There's also a duty, and this is another common law duty, to act for proper purposes. Okay, so you have to exercise, as a director, you have to exercise your power for a proper purpose. And this is, this act benefits, if the act benefits both the company and the individual, if the main consideration was to benefit the individual, then it is an improper purpose. If the main consideration was to benefit the company, then it will not be a breach of duty to act for proper purposes. I'm going to summarize this, okay? But basically, to act for a proper purpose, you have to ask this question. The question is one of causation. The question is, which consideration led the director to act as the director did? Was it for the improper purpose, or was it for a proper purpose? If it was for the proper purpose, then it's okay. Even though there may have been an improper purpose in the background, it's still okay. But if the predominant consideration was for the improper purpose, then you would be in breach of this rule. Now, this duty to act for proper purposes can also be, it's usually followed by the rule of not to make improper use of information. And if you're all familiar with what insider trading is, right? So insider trading is like if you use non-public information from a company in order for you to personally benefit from it, that's one of the ways you can be accused of insider trading. And you can actually do this directly or indirectly. And this is actually found in Section 157 also. I'm going to quickly read this out. 157(2) actually says an officer or agent of a company must not make improper use of his or her position as an officer or agent of the company, or any information acquired by virtue of his or her position as an officer or agent of the company to gain directly or indirectly an advantage for himself or herself, or for any other person, or to cause detriment to the company, right? So the difference is this thing. First of all, directly and indirectly. We will actually deal with this. What does it mean by directly and indirectly later on? The other thing is that this section talks about officers. So it doesn't just apply to a director. So if you are like a company secretary or some other officer of the company besides a director, this will also apply to you. You must not make improper use of information that you gain, and in the end, you end up benefiting from it to the detriment of the company, okay? Okay, the director also owes a duty of care, skill, and diligence. And the standard is often taken from the court looks at the director's position, the role, the size, and the business of the company in order to determine whether or not a director acted with the requisite duty of care, skill, and diligence. Okay. And before we leave this, we're also going to look at, I'm going to quickly touch on Section 156 of the Companies Act. And Section 156 deals with the duties to disclose interests. Okay, unlike the common law duties, this also applies to non-director officers like CEOs and so on. All right. So and I want to clarify here, a CEO does not necessarily mean that you are director of a company, okay? Again, you can be a CEO of the company, but you are simply an employee of the company and you're not listed as a director under ACRA in the company, in which case you're not a director. You may have a very high position in the company, but you're not a director. So there's a distinction here. But under this section 156, a CEO is also liable for this. You're not supposed to disclose interest. You have these duties. And if you breach it, it can also result in criminal liabilities under section 156(15). Okay, so section 156, what does it mean? If you're a director and you have in any way, whether directly or indirectly, interested in a transaction or proposed transaction, which the company must, as soon as it's practicable, declare the nature of its interest and so on. So in other words, you have the duty to declare your interest in a particular transaction if you have an interest in it. I think it is quite clear, as in if you have a direct interest. What it means if you have a direct interest means you personally may be interested in this. You have something to do with this transaction. But what is indirect? Well, that means if you're a director and your family has an interest in this particular transaction, so that's indirect. If, for example, and these examples are actually given in the Companies Act as well, if it's your spouse who's interested in a transaction, or if it's your biological or adopted stepson or daughter, these are people who also may cause you to be indirectly interested in the transaction, and you must disclose them. Okay, and how do you disclose them? Section 156 outlines this. Declare the nature of your interest at a board meeting or written notice to the company containing the details, the nature, the character, and extent of your interest in the transaction. And I just want to stress, it's important to get this done in writing. Yeah, there are some cases that deal with informal disclosure, and those things are not good. So you should really actually do it in writing so that everybody knows about it, and to keep everything above board. Okay. All right. So we've reached the end of this director duties. Now we're going to go on to what are the kind of disputes that can actually arise out of these types of out of either shareholders or directors duties. And the first one is shareholder disputes. Okay, now here we come to the minority oppression claim. What is an oppression against minority shareholders? Now, in a company, right, if disputes are bound to happen. Okay, your disagreements are bound to happen. Whether or not it escalates to a dispute is something else. But common disagreements happen, and you have to see whether or not they're severe enough to constitute grounds to make a minority oppression claim in court. And what are some examples of what they may be? Number one is actions that have been taken to devalue or dilute minority shareholdings. I think we can move on to the next slide. Okay, so if like the majority has taken a lot of actions in order to dilute you as a minority shareholder, then may be possible to go to constitute a minority oppression claim. Unfairly diverting company income to the majority shareholders through things like pay raises, bonuses, or personal expenses, declaring dividends for themselves, but not you as a minority shareholder. These are also possible grounds. Withholding of information that shareholders have the rights to, such as the company registers and records. Again, another good ground to start an oppression claim. Unfair termination or exclusion from management. So for example, if you're a minority shareholder, it doesn't mean that just because you're a minority, you may not have the expectation to be involved in certain businesses of your company. If you have that expectation and it is quite clear, but the majority have been sort of poo-pooing you off, telling you to go and get lost, there's also grounds for a minority oppression claim. Now, what can be done to prevent oppressive behaviors or claims? Okay, I'm going to just really summarize it very quickly for you. The best thing that you should do in order to prevent these types of disputes from happening is to have a shareholder agreement, right? A shareholder agreement helps to put your expectations between shareholders in writing, and then it will actually clearly set out when there's a breach. And in such a way, when everything is clear, it'll be difficult for a minority perhaps to say, majority, because you've already have clarified what the agreement is between shareholders and how they should behave. But going back to minority oppression, this is again, you may have seen it in the slides, Section 216 of the Companies Act deals with what a minority oppression claim is, and also what are the possible remedies that a minority shareholder may have against a majority. Okay, and that is the court may order to regulate the conduct of the affairs of the company in the future, or even to authorize civil proceedings to be brought in the name of or on behalf of the company by such person that as the court may direct. Or the court may provide for the purchase of shares or debentures of the company by other members or holders of debentures of the company or by the company itself. And this is by far one of the most popular remedies that a court gives a minority shareholder is a buyout, right? Because oftentimes the court will see, okay, the relationship between the shareholders is so bad. This is often given in a case of a private limited company. The relationship between the shareholders is so bad, the minority might as well be bought out, and the minority shareholder doesn't want to continue in the business anyway because things have gotten so bad. So the court orders that the majority buy the minority shares up, purchase the shares. And on occasion, one of the remedies is also that the court will order that the company will be wound up, right? In cases especially where the company is no longer a going concern. Now, the shareholder is suffering unfairness. Usually it's an objective test and it depends on the context, right? So it can vary a lot whether or not you can actually be successful in a minority oppression claim. It depends on the circumstances of the case in a lot of times. But generally speaking, the criteria for when a minority oppression case will succeed is when there's commercial unfairness to you as the minority shareholder, where the plaintiff shareholder can demonstrate an injury to him that is distinct from an injury that is wrong, that is done to the company. It is a remedy for personal wrong. Okay, and I want to quickly touch on two things here. I mentioned this earlier, this phrase, legitimate expectations. Now, legitimate expectations can arise from contractual agreements. Perhaps if you're a minority shareholder, you have a contract or certain terms. You have maybe like an informal shareholder agreement. It may not have been in writing, maybe an email, for example, or correspondence between you and the majority shareholders. And then this gives rise to certain expectations that you might have in the running of the company that are not being honored and that are just being blown off by the other side. This is what that's what oftentimes in minority oppression claims, the minority will say there were certain legitimate expectations. And then there are also certain equitable considerations. And that means you could raise the argument, if this is the case, that your business was a quasi-partnership. And what does this term quasi-partnership mean? It means that as you operated the business in a very informal way, sort of like a partnership rather than an actual company. A lot of dealings were not between you and the other partners in your business, were not at arm's length. And there was a relationship of mutual trust and confidence that existed between the parties. Okay. Oftentimes, quasi-partnerships are found by the Singapore courts as existing in family-run companies. So for example, you are siblings, brothers and sisters, and you're running the company and so on. Well, a lot of your dealings was not in writing. A lot of your dealings may have been verbal or oral, or maybe by email or something, or WhatsApps even, right? But there was a relationship of trust and confidence that existed between the parties, and informal agreements and understandings, which form the context for considering whether the specific conduct by the majority shareholders is commercially unfair. So again, this is another key that can be used oftentimes to unlock minority oppression in certain cases. Okay, So, we also mentioned that another two types of shareholder disputes that might occur is the management deadlock, as well as the breach of the shareholder agreement. Okay, I think I don't really need to get into what a deadlock is. I'm sure you all would be familiar with the term, but basically when the management is not able to move forward, right? Because, and oftentimes we see this in companies where there's a 50-50 shareholding, and you just can't move forward because every time you vote, there's a deadlock. Nobody owns a majority. And so how do you get out of this? Well, then one of the ways is to go to the court and to see if the court would find it just and equitable for the company to be wound up or for there to be some sort of a buyout. However, if the company's constitution has an exit mechanism, or if there's a shareholder agreement that provides an exit mechanism, then the court will likely find that the parties should be bound by that. And finally, breach of shareholder agreements. I think I don't need to really get into that all that much. But usually if there is a shareholder agreement, then you can actually sue the other party if they have breached that shareholder agreement. An injunction, may be available to direct that the party vote in a certain way or otherwise act in accordance with the terms of your agreement. And if your shareholder agreement has buyout provisions as well, then that would be much easier to resolve the dispute. Okay, now director disputes. And we're nearing the end here, so thank you for staying with me for this long if you are still awake. I hope it's been interesting for you though. For director disputes, they basically fall under these three different categories: breach of fiduciary duties, and then interaction with minority oppression, and the derivative action. Okay, what is breach of fiduciary duties? We actually already covered that, right? So if any of those duties are being breached by you as a director, you would be liable to the company, and the company can sue you for those breaches. The other directors, for example, can bring an action against you as well, and same with duties under common law, right? Well, I mentioned interaction with minority oppression, and I just want to touch quickly on that, because you see, oftentimes if you're, and we see this very often in practice, is that as a shareholder, and as circumstances of minority oppression arise, oftentimes a shareholder is also a director. Okay, this can be this can actually lead to many different issues arising. Like, for example, if documents are not being given to you as the minority shareholder, they only want to give the audited accounts of the company. But as a director, you see, you are actually also entitled to receive unaudited accounts and to look into the records of the company. And if they're not doing that, then you can actually assert your right as a director for those documents. And I can tell you that documents and documentation is very important in minority oppression cases. Okay, so there's an interaction there between, because a lot of times a minority shareholder may also be a director, or perhaps that minority shareholder may have expectations as if they were a director. And these things can actually help or influence a minority oppression claim. And finally, I want to talk about the derivative action. Right? And the derivative action is encapsulated in Section 216A of the Companies Act. And so when a director is engaged in unauthorized acts causing loss to the company, a shareholder may actually bring an action on behalf of the company against the director. And this action is actually taken in the name of the company. And but you must have a situation where the director acts in breach of that director's duties and has caused losses to the company. The loss cannot just be to the minority shareholder. It must have actually affected the entire company. So, for example, when directors cause the company to enter into unprofitable transactions because they were bribed to do so, then there's a breach of duty, and that's one situation where you can bring a derivative action. When directors breach a duty to not make improper use of his position to gain a personal advantage, for instance, by taking advantage of confidential information accessible only to them, again, you can also bring a derivative action in those cases. Or if they fail to act honestly or with reasonable skill and diligence in discharging his duties, that's also a possibility. And even if the director's own wrongful pursuit of his own personal profit causes no loss to the company might be entitled to sue to obtain that profit. Okay. And I think the last thing to be stated about that is just simply that in the derivative action, you must first, however, get leave of the court. So for example, if you're a minority and you think that the majority shareholder or director is doing something funny, you can bring a claim in a derivative action, but even if the other side, the majority, opposes you from doing so, but you must actually apply to the court in order to get permission or leave in order to sue the director for his actions. Okay, so I think I'm actually done with the presentation side of this shareholders and directors' duties, rights, and liabilities. I'm sure that you guys have questions, and I think I'm going to hand this over to Walter, Silvester, the other Walter. And by the way, we are often confused with each other, but I just want to say that we are not related. Yeah, we're not brothers or anything, but we just happen to have the same first name. So I'm going to hand this time over to him to help answer some of your questions if you have any.
Hi everyone. We have some case studies which were presented, but okay, I find that the case studies, some of them may not be that relevant. If you have any other questions that you wish for us to address, you can just, I think you can put it in the chat function, see whether we can deal with them there. Okay, first question, can I remove a director? Yes, you can remove a director. Generally, you have to look at the, okay, so the most important thing when it comes to how a company conducts itself is you have to look at the constitution. The constitution will define everything that you're allowed to do, that you're not allowed to do. So in removal of a director, generally, you find that for private limited companies, you can do it by ordinary resolution. So as long as you have more than 50% of the votes, you can remove the director. However, you can actually amend the constitution such that it takes more, or I don't know, maybe even less to remove a director. So yes, you can remove a director. Generally, it's 50%. That can, however, be amended by the company itself. Okay, dilution of shareholdings. Okay, this case study, I think the slides presented some options. We can look at them. Generally, when it comes to shareholdings and dilution, right, you have to remember a few things. Firstly, your ordinary shares and any shares that you have can be diluted, but you can actually specify that some shares cannot be diluted. So one issue that we find that we face when it comes to companies is when the company is initially founded, it's not stated which shares can be diluted, which shares cannot be diluted. So founders who actually start up in a company and they pump in money and they buy the shares, they may find that further down the road, because the company does really well, or because a very aggressive group of investors or shareholders come in, they find that their shares can get diluted and they're left with very little. So an important thing that you have to do if you want to protect yourself from something like dilution, you have to specify it in the agreements. So the best place to state what can and cannot be diluted would be in your constitution. So I know it sounds boring, but really it all goes back to the constitution. The constitution will define what you can and cannot do. So there are actually two things that I would advise when it comes to dilution and protecting yourself. One, put it in the constitution, define that certain shares cannot be diluted, you protect yourself. Two, have anti-dilution provisions. So this can be between directors, between shareholders themselves, to say that, okay, we will not, contractually, we will not allow dilution for certain types of shares. So this will actually protect yourself from dilution. Your shares will be protected. At the end of the day, you will get what you want in terms of your shareholdings. Okay, a company has two shareholders, one majority, one minority. During an AGM vote, get into a dispute. Can the majority shareholders sign the resolution without the minority shareholder? Okay, again, you have to go back to the constitution. You have to see what the constitution says. Generally, the law is if most matters are decided by majority. However, in the constitution, you can actually specify that certain things require a different percentage. So you can say that certain things like removal of directors, acquiring assets of above a certain amount, say $1 million, giving loans of a certain amount, maybe $1 million. You can specify that these matters, you require a special majority of, you can define that majority, you can say it's 75%. So whatever can be done, you can specify it in the constitution itself. Generally, yes, 50% is enough to remove a director, yes.
Walter, I think I just asked because I think all these questions are sent to us by our readers. So I think this question was actually asking like in terms of management deadlock, and I think in the default agreement, sometimes the quorum is like 2 people. So you need 2 people for a meeting. But the point is that the minority, in this case, the minority is not happy with certain things and refuses to budge. And the person maybe he owns like 99% of the shares, the other person owns 1%. But in terms of meeting, the other person refuses to attend or does not do anything, does not approve of any resolution there. So is there a practical way around it?
Okay, so this you have to look at the deadlock provisions. So if there is a deadlock, in a case like this, it may not be a deadlock in terms of voting power, it may be a deadlock in case of one party just not doing anything. And one thing that we found when looking at the general constitutions and shareholder agreements is that there are no deadlock provisions. What do you do in a case where one shareholder simply refuses to sign? So what we do for our shareholders agreements are we deal with this and we say that, okay, in a specific situation, maybe the majority shareholder is supposed to send the resolution by email to the minority shareholder, maybe give him 1 week to reply. If he doesn't reply, he must send by registered post. If he doesn't reply, then the majority shareholder is allowed to proceed to have the resolution accepted by the company. So unless this is stated, right, you are actually left in a deadlock and you may have to go to court to ask the court for an order that, yeah, this provision, this resolution should be accepted because one of the shareholders is not replying.
Understand. Okay, that's great. Then now I guess we can go on to, we have a couple of questions in the chat. So I think we just go down the list. So you already answered. So can a minority shareholder request for transaction of a company's account? I think you mentioned that directors definitely can, but can minority shareholder request for companies to view a company's account?
Generally, no. So what the minority shareholder, what all shareholders are entitled to are the audited accounts of the company, which are placed before the AGM. So at every AGM, a company is supposed to place the audited accounts before the AGM, and everyone is entitled to inspect that. If you want to have something more, it has to be done by way of request. The company can actually say no.
Great, that's pretty straightforward. Then can a separate, is there such thing as directors' agreement that overrides a constitution? I think you're talking about shareholders' agreement.
Yeah.
This was a bit confusing to me when I read it because I'm not sure what he means by director agreement. Usually it's a shareholder agreement, and that sometimes in certain cases does override the constitution. And I say that in a very loose way. But directors are bound to act according to the constitution. And actually if they're not shareholders, they're not bound by the shareholder agreement either. So usually it's the constitution that would govern all the acts of a company, including the directors.
Yeah, one thing that I'd like to point out, so you have a constitution, it's been in place since the company began. Okay, later on down the road, the shareholders who run the company, they think that you want to amend the constitution. So there should be a provision in the constitution to allow shareholders to amend the provision. And the shareholders can actually come up with a new agreement, a new shareholders agreement that amends the constitution. So it doesn't mean that you're stuck with the constitution. You can actually do that, but the shareholder agreement, whereby the shareholders are allowed to amend the constitution, should specifically state that, okay, all the shareholders are on board. We wish to amend the constitution to this effect, and then set out the amendments in the constitution that the shareholders want to do, and then the constitution can be amended. So the constitution, while it's a powerful document, it's actually controlled by the shareholders of the company. So how many, what's the percentage required to amend the constitution? That can be decided by the constitution. So it's really important that you look at the constitution. I know Accra, they have their model constitution. My advice is, if you're really going to do business and you really intend to do it well for long term and it's substantive enough, you would probably want to take a look at that and not adopt it wholesale. You would probably want to make amendments. And that's something that we actually do for our clients. We actually go through the Accra model constitution and actually unmodel it so that it suits the clients and suits the shareholders of the company.
Hope that answers the questions. And Raymond, if it doesn't answer, you can feel free to either speak up or you can continue in the chat. Yeah, so I'll move on to the next question. If the directors are given a mandate in a previous AGM to allot new shares, and I suppose for other things as well, so do the shareholders have any recourse to dispute the dilution? So once directors have already been given the mandate in the previous AGM, can you still challenge it?
Yeah, this does not sound like, so if the shareholders have already consented, to the, in an AGM, and it's actually a written resolution already. So the mandate has already been given to the directors to issue the shares. Then why are they calling it into dispute now? I mean, if they've already given authority to the directors to do it. So this does not sound like it, unless there's some other things that are happening in the background, like they weren't properly informed, or they are now alleging that there was deception or something like that during the AGM. I mean, but in the general course of things, as this question doesn't really put out anything other than this, I don't know how, I don't see how the shareholders can go back on a consent that has already been given.
Okay, yeah, so like Esther, I hope that answers your questions. If not, then yeah, okay, thanks. So we move on to the next question. If shareholder agreement doesn't exist, then company defaults to constitution by governing relations. So I think you guys have answered that it is the constitution that usually governs the relation with shareholders, directors, and the shareholders agreement will govern relations between the various shareholders and perhaps affect what they do as directors as well if they are majority shareholder. Okay, so is there a case voting by poll? No, I think this Dorothy's answer was a response to Walter's answer about what if there's a management deadlock in terms of voting at the company. So we will move on to the next question. So if there's a conflict between, I guess, shareholders agreement and what directors should be doing under Constitution, what should they do? I guess, because I assume a shareholders agreement, if there are 3 shareholders, not all the shareholders might be party to a shareholders agreement. So there could be some conflict in terms of what the directors should do in the interest of the company and what the directors perhaps should be doing according to the shareholders agreement. And then Constitution might not be amended, according to the shareholders agreement as well. So that might be another thing. So do you guys have scenarios like that?
Yeah. These are scenarios that could happen, but we try not to let these kind of scenarios happen. So you see, a constitution can sometimes be superseded by what your shareholders agree in an SHA, right? So the SHA is signed and it contains clauses that may be sort of inconsistent with the constitution. That is why whenever we are asked to draft a shareholder agreement for our clients, we always advise them, you need to update your constitution also. So send us your constitution, and then we will take the draft that we've drafted and we will compare it with the constitution and we will update the constitution so that there's no conflict. Okay. In the case of what happens if like the shareholder agreement is signed and it conflicts with the constitution, oftentimes if something is missed out, we usually include a clause where it says that the shareholder agreement takes precedence over the constitution, and that the company will do its best, or rather the shareholders will do their best to update the constitution after this. So that means that in the meantime, right, where the shareholder agreement is actually slightly different from the constitution, the shareholder agreement will still take precedence, because that was the intention of the parties, you see, so that there can be no dispute later on where it says that, oh, but everything is inconsistent. No, but there's a clause in there that says that the shareholder agreement actually will take precedence until the constitution is amended. So I hope that's helpful.
Just one thing to point out, your shareholders agreement, right? It can be between, just say you have 10 shareholders. It can be between 5 shareholders. Okay, there's a shareholders agreement between 5 shareholders. It governs the relationship between these 5 shareholders. But if you want to have the company align with the shareholders agreement, you need the company and all the shareholders to sign off on that shareholders agreement. So you can have different types of shareholders agreement. You can have one between like 70% of the shareholders, one between 30%, but the company is not bound by it. The company is bound by a shareholders agreement if it's signed off by all the shareholders, 100% of shareholders, and the company itself. So that we've come across shareholders agreements where the company is not party to the agreement. That it shouldn't be that way. If all the shareholders are signing the company should also be signing the shareholders agreement.
Yeah, I think that answers the question. So for our next question, I think I picked 2 questions that are kind of related. They are all about, if let's say you are in a company where there's a foreign shareholder, you may be a director or shareholder in them, but then I guess you're a director, maybe a nominee director for foreign shareholders in a company. How do you get out of this situation? Because maybe the company is losing money, their liabilities, maybe they're doing something illegal, but you're just a local nominee director and the shareholders and other directors have disappeared, and you have, here it says, no access to accounts or management of the company. So how do you get out of this situation? I think it's to wind up the company, right?
Actually, you're stuck. You can apply to wind up the company. So we've come across these kind of situations where a director is just stuck. The foreign shareholder just disappears. The director has to either go through the trouble of winding up or just sit there. And but there could be consequences later on, because you don't know exactly what the foreign shareholders have done with the company. If the director doesn't have full information, full access to company records, full access to the company's activities, the director could actually end up in trouble, because if he's not controlling the company, right, he shouldn't have signed up as a director in the first place. Okay. So the obligation, the onus is on a director to actually control the company, align with the shareholders' instructions. If that doesn't happen, then the director is actually exposing himself to liability.
Yeah, so I guess in such a situation, if it has already happened, then I would think that it is safer to wind up, and at least the bank accounts are closed, and you're only responsible for what happens maybe before that.
The safest thing to do would be that, yes.
Okay. Then the next question is, if a director's conflict of interest under Section 156 is not disclosed, then how can a former shareholder pursue?
Well, I guess for this issue, you would have to look at the prejudice cause. Okay, so if there was a conflict of interest and it has actually harmed the company, obviously the shareholder, the company has recourse against the director. But as to exactly what is the recourse, you have to look at the damage that was caused. If there was no damage caused, the recourse may just be something to get rid of the director. You get the director terminated and you get him removed. But if there was damage caused because of this conflict of interest, then there's actually a potential for litigation to say that the director should actually make good this damage caused.
Yeah, I think in this question, you talk about former shareholders. So the only scenario I can think of where there's a lot of damage is if, like, I guess the non-disclosure of the conflict of interest caused you to sell your shares, causing you to become a former shareholder, and then I guess it recourse to maybe the difference. You might not have sold the shares if you knew about like conflict of interest and all that. So that's the scenario I can think of. Yeah. So next question: if a quorum for circular is not defined in the Constitution, does it follow the same quorum as physical meeting? Yeah, I think you're talking about like now, if you do a physical meeting for approving resolutions, then now it's circulating resolutions. I think that what you need. Now you're circulating resolutions for signing. Do you need the same number of votes and signatures? I assume it has to go with the company's constitution with regard to how this is conducted, right? So
Yeah.
So I think
I guess in terms of percentages, yes, it would.
Yeah, it should. I think it should be the same. It should default to the same in this case.
okay. So I think the last question, would it be mandatory to amend the constitution of a company to be consistent with the provisions of shareholders agreement? I think you guys have explained just now that in the shareholders agreement, if for lawyers they have drafted good ones, then you will actually force the majority shareholders to recognize that they should be trying their best to amend the constitution. And even if it doesn't, then the shareholders agreement should take precedence over the constitution. So I think that actually brings us to the end of our Q&A and also our webinar. Actually is great. The time is 2 p.m. now. So so after this Q&A now, it's just like you guys could connect with us on Singapore Legal Advice social media accounts, and there's Silvester Legal's LLC's email. So I would just like to thank you guys for joining us today and to explain to everyone what's explain about shareholder and director disputes. I myself have found it tremendously useful, and so I hope that you guys have also found it very useful. And if you have any questions or you need any legal consultation or advice with contracts or litigation disputes, feel free to contact Silvester Legal as well. So that's it for the webinar. For the slides, we'll share the slides here. We should also have a recording. For that, we will either send it out through probably through Silvester Legal's own newsletter channels, and for ourselves, we also should be sending it through our newsletter feedback form. So thank you very much for joining us, and have a good day ahead.
Yeah, thank you all for joining us.
Thank you, everyone.